Over there. I'm not going to tell you again.
I have all of my stuff.
That's fine. No, I don't want you in the car.
Okay. I'm sorry.
No, you slammed me on the...
Yeah, you don't charge me like that. Did anybody hit anybody here?
No!
Okay, no one slapped anybody,
No,
threw things at anybody?
Grandmother calls 911. A deputy uses force on someone who is not a suspect. A felony charge is filed, then quietly reduced to a misdemeanor, which decisions here were legally justified, and which ones crossed a line.
I'm leaving peacefully.
You're not leaving yet. Go over there.
We're moving.
Go over there.
We're moving.
Go over there. I'm not going to tell you again.
I have all of my stuff.
That's fine. Set it down.
I'm leaving peacefully.
No, you're down. You're not leaving yet.
I'm leaving.
Come up here by the porch.
I'm leaving
You're over here.
peacefully.
Sit down. No. No, I don't want you in the car.
Okay. I'm sorry.
Get back. Get back. 2 North 71, 7094 priority. Sit down.
Okay, I will sit down. Sorry, I was.
Sit down. You okay?
No! No, you slammed me on the...
Yeah, you don't charge me like that.
I'm sorry. I thought you wanted me to go in my car.
I told you not to go in the car.
I'm sorry. I was confused.
I was pulling my drawers out so I could take
I don't care what you're doing. You charged me.
I mean,
Stop moving your hands. Do you need EMS, Sky?
I mean, you busted on my lip.
I didn't bust your lip.
Baby,
You already had that on your lip. That's all dry. Come sit over here.
Please, sir,
Sit down. I'm not going to tell you again.
Sir, I'm 150 pounds.
I don't care. You're not going to do what you want. You're going to do what I want.
No, we do. We are. We're gonna...
Sit down. You're not going to play by your rules. You're playing by my rules.
Well, may I ask why you threw me like that?
Because you charged me and I told you to get back.
We're leaving.
I'm here now. You're not going anywhere. Go on here. So, something with her and the grandma. Tell her to go sit down. She doesn't want to sit down. He wants to go get in the car. I tell him not to get in the car. So I go to detain him because he doesn't want to listen. She charges me. And I pretty much just stiff arm her and knock her down.
Because last time I spoke
that's
to you,
why I asked for
officer,
party.
and you told me to sit in the car. Did you like loosen up my
No,
jaw?
you just sit there and listen. What's your first name?
Luke?
I was pulling my drawers out, so I can get all my stuff in my drawers. It wasn't hostile whatsoever.
Okay.
My nana is just not like.
Hold on a minute. Ma'am, listen. Take a couple deep breaths for me, okay? Do you live here with your nana?
Like
What? I don't understand.
on my mail address.
Yes.
Yeah.
I get here, they're outside, and they're trying to move out. I'm walking her over there to sit down so I can keep them separated. I told him that.
That's my fiance.
Stop, I'm talking right now. You're not talking.
I'm sorry.
He doesn't want to sit down, and then he wants to get in the car. I told him no. He goes to get in the car anyway, and he wouldn't listen, so I pull him out. I put him in cuffs, and she charges me. And I literally just stiff arm her and knock her down. Okay.
You know what? I've been dealing with y'all since I was 13. I'm not even finna ask to loosen these goddamn cuffs.
Listen to me.
My nana asked me to take out the I have text if I can get my phone. I don't want to go to jail.
Okay.
Look at me. I
That's
am
fair.
white, 115 pounds, blonde hair. I don't want to go to jail. So I called 911 to ask what were the ramifications. Sorry, these hurt so bad. I hit my head.
Do you need EMS? If you want EMS, I'll call EMS to check you out.
I was just trying to leave.
No, you aren't. You charged me. You see anything that happened between her and her grandmother?
Okay, she was grabbing her like childhood pictures, and then she accidentally knocked over like a vase or something.
Okay.
She was on the phone with the bank, and she's very bipolar.
Okay.
And she has an issue where she sits behind closed locked doors for hours. I think that my nana just thought that maybe I was taking things with an attitude.
Okay, she called the cops.
And she was holding wine glasses. And this will make sense. I'm a server.
Okay.
And I didn't want her to break her great-grandmother's wine glasses because I was just trying to help.
Okay, so did anybody hit anybody here?
No.
Okay, no one slapped anybody,
No,
threw things
the
at
only
anybody,
person-
threatened anybody?
No, the only person who really got hit was me by an officer.
No, but as far as you, him, and your nana, no one in that three of you hit
me
anybody.
and him just want to get my cat and go.
Okay.
Okay. So he got here and you came running out of the house.
No. He slammed my boyfriend against the car and I ran to my boyfriend. But I didn't know that I couldn't go after him.
How do you know that you're not going to shoot him in the back or something? What do you think he thinks? We don't know this. You'd be surprised at what people do sometimes, okay?
Okay, yeah. Oh, my bad. That was the officer I was talking about.
We told you multiple times, just sit down.
Okay, Sky, listen to me. I got something to read to you. Having those rights in mind, do you wish to talk to us?
Yes.
Okay. All right. So what happened here with your grandma today?
I heard my Nana on the phone with the bank. Now here's the thing, guys. My Nana's door is very, very thick.
Okay. So
I'm sorry.
what transpired in the kitchen earlier when your grandma was washing dishes?
So I'm a busser and a server and a bartender.
Okay. So you're trying to help her with the dishes, and then what happened?
I tried to shimmy in between her
And the open dishwasher.
No.
Okay.
I shimmy through this way, and I think I hit her a certain like my shoulder or something, but she never fell.
Why would she tell me she fell? Why would she tell me you pushed her?
I didn't. I don't know, but I literally, I swear to God, if there are cameras up, I was just trying to help her clean dishes.
Okay. Well, right now you're going to be going to jail for domestic battery on a person over the age of 65, which is a felony. Okay. So go ahead and stand up. 2 North 7. Show me 1015 one white female.
Baby, what's that?
They're arresting me, felony charge.
What? Wait.
Stay down.
Why are you being so rough with me?
I'm not being rough with you. I'm just putting you where you need to be.
Stay right there.
In the bags, you know. Oh, I'm sorry.
Stay right
I'm sorry.
Okay.
That's a depressing.
No, baby. I'm sorry. I'm so sorry.
How many times do I have to tell you? Sit right there.
Where is she?
She's fine. She's fine.
So you could call your mom to come get you because you're not okay to drive. So whatever you guys were doing, drinking, smoking, pills, I don't know what it is, but you're under the influence of something. Call your mom and you have your mom come get you.
No, but where is she at?
She's going to jail.
For how long? For how
She has to see a judge. It's domestic related.
No, but like...
Tomorrow morning, she'll talk to her judge. Okay, EMS is here to check the back of your head to make sure you didn't hit the back of the head. She said she wants you to just check the back of her head.
What's hurting you right now?
Head.
So your head hurts.
The back of your head?
I'm sorry.
Does it hurt at all back there?
Baby. Wait. Can I?
Stay over there.
I
Stay
love
right
you
here.
so much. I'll wait for you.
Post my bill.
There's no bail on his line there.
What?
There's no bail. You'll see a judge in the morning.
Baby, I love you.
You're
I
not
love
listening.
you.
You want to end up in handcuffs again?
No, I'm not gonna.
Just start listening.
Baby, it's
quicker.
okay.
Let's go step back in here.
Ouch. Ow.
That's all you. I'm just holding your hands.
Where is she going?
She's coming here. She's coming to pick you up. Your parents.
No.
Yeah.
No, I just want her.
So I grab him to detain him, and she charges me from the front.
Oh.
I just like stiff arm clotheslined her all at once.
Sounds like she was out of control when you got here.
All right, this female deputy is going to search you. Step out. Spread your feet.
Yes.
Wider.
You're gonna be okay.
Nah, dude.
You're gonna be all right.
Yes, sir. Yes, sir.
I got a lot of paperwork to do. Yeah, you'll be able to do it. If you'll just stay with him, because he can't drive.
He's got to stay on the car. I already called his mom, and they're on their way here.
Hang up.
What? Yes.
Stop calling grandma. And she doesn't want you ever to come back again.
It's night trespass. So once you leave here, you're not coming.
I'm not going to say it again. Take a seat.
Alright, well, motherfucker, I'm not.
You want to go to jail?
I'm sorry. Hi, I'm his father. Unfortunately.
Long story short is they've been arguing, I guess, this morning. We've been out here throughout the day.
I swear to God, I'ma marry that and there ain't nothing you can do about it.
You can homeboy.
They've also been taking money from Grandma.
He's been part of it?
They took $400. Well, Sky pushed Grandma today in the kitchen, knocked her over. So Sky got arrested for felony battery.
Your grandma had to be checked out by EMS. That's what she's stating. That's what she's alleging. Your boyfriend said he didn't see it, so you're going to jail.
We didn't arrest him because we didn't have a reason to at the time. I believe he was taken to the ground though because he wouldn't listen to officers earlier.
Show some respect to your mother.
So you can haul him away. What? You can haul him away, officer.
Yeah. All right. If I get another call today, I'm telling you right now, you're going to jail. So don't have me come back out.
Can I get my red belt?
Luke, get off the property before you're arrested for trespassing.
Can I get my red belt?
Luke, you're good to go. Stop.
Oh my God.
You're about 2.2 seconds away from going in the back of my car and joining your girlfriend in jail.
I'll walk over to those doors.
This analysis examines 3 legal flashpoints: the authority to detain a non-subject during a domestic investigation, the use of force against a non-suspect, and what Florida law actually requires to sustain a felony domestic battery charge. The deputies acted within the law in some respects and against professional standards in others. Where exactly those lines fall, and what the evidence ultimately showed, is not as straightforward as the initial charge suggested. Under Terry v. Ohio 1968, law enforcement may briefly detain any person connected to an active investigation when supported by specific, articulable facts. Florida Statute 741-29 separately mandates separation of all parties in domestic calls. Both legal standards applied from the moment deputies arrived at the scene. Graham v. Connor, decided by the Supreme Court in 1989, is the governing standard for all use of force analysis in the United States. Force must be assessed using an objective reasonableness test, measured at the precise moment it is applied, not before, not after. Graham establishes 3 factors for courts to weigh: the severity of the underlying crime, whether the subject posed an immediate threat, and whether the subject was actively resisting or attempting to flee. None of these factors operates in isolation. The critical legal distinction in this case is that the subject of the force was not a suspect at the moment contact was made. She had not been accused of any offense. Including a multivitamin, applying Graham to a non-suspect bystander raises questions under both the 4th and 14th Amendments to the United States Constitution. Florida Statute 776, 5 authorizes officers to use force reasonably necessary to defend themselves in the course of a lawful investigation. The stiff arm technique falls within the soft to hard empty hand control range of the use of force continuum. Whether it met the reasonably necessary threshold when applied to a non-suspect is a separate and contested question. Florida criminal justice standards and training commission guidelines require verbal de-escalation as a first intervention before physical force is applied, particularly when the subject has not been identified as a suspect or a threat. The absence of a prior verbal warning is the core professional standard criticism here. Miranda v. Arizona 1966 requires that before any custodial interrogation, officers must advise the subject of the right to remain silent and the right to counsel. Deputy Zerillo administered this advisement completely before asking a single substantive question. This constitutes textbook compliance with a 60-year-old constitutional mandate. When a subject waives Miranda rights and provides a statement, that statement becomes fully admissible as evidence at trial. In this case, the post-Miranda statement confirmed physical contact with the victim, establishing the actus reus of battery. The question of intent, the mens rea, remained open. Florida Statute 784.8 elevates battery to a 3rd-degree felony when the victim is 65 years of age or older. Required elements: intentional touch or strike, against the victim's will, with the defendant's knowledge of the victim's age. Maximum sentence: 5 years. Intent is not proven by contact alone. It is a legal inference drawn from the totality of the circumstances at trial. When the defense frames contact as accidental, intent becomes the central contested element, and the burden rests entirely on the prosecution to disprove that framing beyond a reasonable doubt, including a multivitamin, the reduction from the felony under Section 784.8 to misdemeanor under Section 784.3 is not a procedural formality. It reflects the prosecutor's calculation that proving intentional battery at trial carried significant evidentiary risk. This is the practical meaning of the intent element under Florida domestic battery law. Under Florida Statute 948.1, adjudication withheld means no formal conviction enters the record if probation is completed successfully, combined with the felony to misdemeanor reduction. This outcome substantially reduced the defendant's long-term legal exposure from the original charge. 3 lessons emerge from this incident. Miranda waivers carry direct evidentiary consequences that cannot be undone. Force applied to non-suspects requires a higher legal justification than force applied to suspects. And a felony domestic battery charge requires proof of intent, not merely proof of contact. If a verbal warning had been issued before physical force was applied to a non-suspect, would the legal analysis of that force change under Graham? And if it would, what does that tell us about the gap between what the law technically permits and what professional standards actually require? The felony charge was filed based on the grandmother's account and the defendant's own statement. The felony charge was later reduced. The defendant pleaded to a lesser offense. At what point in that chain did the evidence actually support the charge? And at what point did it not? Every decision made in this encounter had a legal consequence. Some were predictable, some were not. The question worth considering is this: which party in this incident best understood the law? And in the end, did that understanding make any difference?